Greetings, viewers. Welcome to the 11th edition of our True Patriot podcast. Today, we read into the Public Service Act Amendment Bill, and we are lucky to be hosting labor expert Edzai Matika. Mukoma Edi, kusangana nevanhu and just introduce yourself more in detail.
Thank you so much, Obet. My name is Edzai Matika. I am a lawyer with Matika Gwisai and Partners. I mainly specialize in labor law, and I have a special interest in public service labor law.
Thank you so much. Now today we are looking at the bill which was gazetted on the 1st of August. I think the Public Service Act Bill, Amendment Bill. What motivated this particular amendment? Why did we need these amendments? What is the purpose to begin with?
So I start by taking you back to 2013. So you notice that in 2013, Zimbabwe adopted a new constitution, and as you are aware, the constitution is the supreme law of the land. So the constitution was introduced in 2013 as Constitution of Zimbabwe Amendment number 28 of 2013. So that constitution brought with it a lot of progressive rights, and which included the labor rights as well. So most of the acts of parliament that we had in terms of labor law were supposed to be aligned to the new provisions of that particular constitution. So it's just said that more than a decade later, the Public Service Act had not been amended to align its provisions to the provisions of the 2013 constitution. So if you now look at the proposed bill, the memorandum itself captures the purpose of the amendment to the Public Service Act, which is to align the provisions of that particular Public Service Act with the Constitution of Zimbabwe, which was adopted in 2013. So that's the primary purpose of the amendment. Though if you read through the bill, you actually see some other minor amendments which do not deal with the Constitution directly. But the major amendments, they actually an attempt to align the provisions of the Public Service Act to the Constitution of Zimbabwe.
But from your reading, do you think the proposed bill meets the expectations of the Constitution that you are alluding to? Does it really align the Act to the Constitution in full? And you can also speak to the issue of international labor standards. Does this bill bring us closer to meet the expectations of the Constitution and international labor standards?
I will answer that question in two parts. I may say yes and no. Yes, in that most of the provisions that were brought in by the Constitution have been incorporated into the amendment. Looking at the Public Service Commission, there are new provisions which deal with the Public Service Commission, its functions, its composition. Those issues are actually found in the Constitution, and they've been incorporated into the amendment. If you check the preamble itself, the functions of the Commission, duties, they mirror what is contained in the Constitution. You also notice that there are certain labor rights that were brought in. For example, the right to collective job exchange. There is also mention of the right to collective bargaining. Quite importantly is the right to maternity leave for women. That was extensively covered in the bill. But the no part now is that the proposed amendment leaves a lot in terms of what must be done after the amendment. For example, where it speaks to the right to collective job action, it actually says the procedure will be dealt with in terms of service regulations, which are to be made later. The issue of collective bargaining, collective bargaining, in a sense, they just mentioned the word collective bargaining, but it did not define, did not set up the structure. They simply said collective bargaining will be dealt with through service regulation. So there is no much ground that will be covered by the amendment, where they say we are going to leave this to the minister and the commission to deal with this. So it will be like giving with the one hand and taking it with the other, because these regulations will be made in a unilateral manner by the employer part. So it doesn't necessarily mean the rights have been given. So in terms of matching international standards, in respect to the right to collective bargaining, I would say there is no standard that has been met. Even in trying to embrace the right that was brought into the Constitution, there is nothing really in terms of that. And also the issue of other related unfair labor practices, they have not been covered, other than where they are talking to the right to maternity leave. That's where they just state unfair labor practice. So basically the answer is in two parts. Yes, they tried, but not to the standard that too is expected of an act of parliament.
Okay, thank you so much. Let's go deeper into the issue of collective bargaining. Maybe you can take us through on what was currently obtaining in the civil service with regards to collective bargaining. And some of our listeners might not even know what collective bargaining is all about. So maybe just dig in from the definition itself, then maybe explaining what was obtaining on the ground and what the amendment really seeks to do, and what are the changes that have been made, and where the gray areas still remain that still is to be addressed.
Thank you, Obet. So just to put our listeners and viewers into perspective, collective bargaining is a process whereby the employer and the representatives of the employee negotiate on the terms and conditions of employment, including salaries, allowances, remuneration, leave, and other related conditions of employment. And the ultimate goal is to come up with an agreed position, which is called a collective bargaining agreement. So that's essentially what collective bargaining means, where employers and employees sit together, come up with terms that govern the employment relationship in terms of rights and benefits of the workers. Mainly it covers the remuneration part, salaries, allowances, and other benefits. So now looking at what was obtaining prior to the 2013 Constitution, and even after the 2013 Constitution, is that conditions of employment for members of the civil service were being determined by the employer in a unilateral way. They will tell us that there is a negotiating forum, which was called the National Joint Negotiating Forum, commonly called the NJNC, where you would hear a board representing the employees called an Apex Council would meet with the representative from the government itself. That process, unfortunately, did not amount to collective bargaining. It was rather a consultative process. because there was no legal framework that accorded employees in the public service the right to collective bargaining. So you would notice that the president will just wake up someday and say, I have given an allowance of $100 to all workers. No negotiation has been done. It's just a unilateral way. Then you will notice that there were also provisions, particularly in the Public Service Act, which would say the Public Service Commission will engage in regular consultation with employees or their unions and try to come up with the conditions of service. But that provision would also go on to say absence of consultation or absence of agreement would not nullify the conditions set by the Commission. So that in itself negates the whole essence of collective bargaining. So what I would say is that the NJNC and any other form that was being done in the name of determining conditions of service was not collective bargaining. So that's the position which is still there. And to also deal with the bill, what it is proposing in terms of collective bargaining. I will hasten to say the word collective bargaining is mentioned once in that proposed bill. It is mentioned where it says that public service regulations will deal with the issue of collective bargaining. So the Act does not embrace in full the right to collective bargaining because it is silent. It does not say employees in the public service have a right to collective bargaining. Even if the right was given, the Act still retains Section 20 I mentioned earlier, which says the Commission shall engage in regular consultation. So consultation is not collective bargaining. Consultation is actually a discretion. And even if you are consulted, it doesn't mean that if you don't agree, there will be a nullification of the process. So if Section 20 of the Public Service Act is still there, which says whatever the Commission comes up with as conditions of service are not nullified because there was no consultation and there was no agreement, then the whole essence of collective bargaining is thrown away. It renders Section 65, subsection 5, paragraph A of the Constitution meaningless because collective bargaining must result in an agreement. So what I would say is that the bill does not in any way embrace collective bargaining. Unlike where it mentioned about collective job action, it actually says employees have a right to collective job action. But in terms of collective bargaining, there is no such equal provision. So in respect of collective bargaining, there is nothing really.
Thank you so much. So in short, we are saying Section 20 of the old Act still has to be struck off, and we still have to see the bill capturing Section 65.5, and I think that's very helpful. Now, looking at the issue that you just raised on collective job actions, where you say there have been a bit of progress. I know from the past it was completely proscribed to have a job action in the public service.
Yes.
Maybe if you could shed more light on the fundamental changes that are being made, and maybe if there are possible pitfalls that can still be weaponized by the employer against employees, if I may say.
Yes. So in respect of collective job action, I would say that is there is a progressive provision that has been brought by the bill. The bill seeks to amend Section 24 of the Public Service Act. Section 24 deals with trade unions, associations, and organizations. So it adds to that section, it adds subsection 6 and 7. So subsection 6 is in express terms that public servants have a right to collective job action. So it's clear like that. then it excludes those who are in the essential service. That's where we have a difficulty in respect of essential service. Essential service, it's actually defined in that particular bill as those services where if they are withdrawn, the lives of persons or property will be in danger, immediate danger actually. So not all employees will be essential service. But the difficulty that we have with that is the defining of essential service is left out to the minister in consultation with the commission. So we may find that the declaration of essential service notice may actually be stricter and very broad in a sense that it may capture every employee in the public service. And the difficulty that is also there in terms of defining what essential service is that there is a gap in respect of the right to challenge the declaration of essential service. So suppose the minister comes up and say all employees are in the essential service. There is a difficulty that one may not challenge that. There is no procedure to challenge that. Unlike under the Labor Act, there is actually a right to appeal to the Labor Court if one is not pleased with the declaration of essential service. So it is pertinent that there is also an equal provision in terms of the Public Service Act to say if the minister says this is an essential service and one is not happy with that, they can actually challenge it through the courts. Then another danger which is also there is on the procedure to embark on collective job action. So that's a weapon that may be used to restrict the right or even eliminate it, because the procedure to embark on collective job action is actually left out to regulations which will be made by the commission and the minister. So there will be a difficulty there because employees may not participate in the process, and the process may actually be stricter than the one that is provided for under the Labor Act. So it is a position that it may be streamlined in the parent act to say to resort to collective job action, you must give it, for example, 7 days notice. You must comply with the 1, 2, 3 process in the act, so that it can actually be subjected to public scrutiny, and also it can be challenged in the long run. So if it's left out to the minister as well, the minister can actually give the right in terms of the act, but strictly restrict it through subsidiary legislation in the form of regulations. So I suppose those are loose ends which must be tied in the act so that the minister may not exercise powers in a so restrictive manner to actually take away the right given by the act.
Yeah, so generally we have seen ministerial regulations being used to roll back on rights that are already provided for. So instead of just providing an administration framework, we're seeing some regulations which comes back and rob people of the rights that they've already been provided for in the Constitution or in the Act. Maybe what kind of safeguards for maybe between employer and employee relations could be put in place to ensure that we don't have such regulations that can infringe on existing rights? Are there any possible safeguards that we might think of when we are getting into the lawmaking process?
So I think in respect of workers, one avenue is that these powers that are being given to the commission or the minister can actually be exercised by the legislature. It's quite easy to make provisions with respect of the right to strike, because there is an equivalent provision, for example, in the Labor Act, so which was made by the legislature. What is the difficulty for the legislature to put those safeguards or procedures in the parent act, that is the Public Service Act? The other alternative, if it is impossible for the legislature to do so, is to subject the making of such laws through a process of a collective bargaining. You understand that in the private sector, most of the issues are actually dealt with through the National Employment Councils, for example, where the employers and the employees party, they meet, try to find common ground. So that is another way of dealing with us with such, so that the minister may not exercise so much powers which may take away rights. So if that process may be allowed, where the making of any service regulations which govern conditions of employment be subjected to a collective bargaining process, and a collective bargaining agreement is reached, then the collective bargaining agreement be published as a statutory instrument now. Not to say the minister and the commission can just sit in their boardroom and come up with the regulations governing employment matters without the employees being involved. So I think that's the better option as well.
Okay, great. So yeah, I see there's this milestone, I think, which we should be celebrating, where the issue of maternity leave, absolute paid maternity leave. I think this is an area we should be celebrating. We used to have maximum of 3, I think, and other conditions that were attached to it. Maybe if you could just elaborate what this means, and maybe what improvements might be made with regards to the enjoyment of maternity leave.
Thank you for that one. I think, yes, maternity leave is actually coming as an absolute right. And yeah, indeed is worth celebrating because all the restrictions that were there have been removed. There were restrictions in terms of a situation where an employee can only be given paid maternity leave if they've completed 1 year of service, and they could only go for another maternity leave after a period of 24 months, which is 2 years. And also that if you exceed 3 periods, you cannot be given paid maternity leave. It will be unpaid maternity leave. So those provisions have since been removed by the new amendment, so which is quite commendable. What we think may also need to be considered now with the modern trends is the issue of pregnancy leave, because you understand maternity leave is only granted some few days before, or some few weeks before the expected date of delivery. But the employee might face some other complications in terms of pregnancy. So maybe that period can also be covered through maybe introduction of a pregnancy leave. And also, you also note that husbands go through a lot during the period of maternity leave with their wives, for example. So paternity leave can also be taken into consideration, but not to take away what has been given so far. What is been given so far is quite commendable, and we are impressed that the legislature embraced that right as it is in the constitution without any restrictions.
Now we go to the issue of trade unions and associations. Now there's this terminology where there's recognition or registration. I understand in the old legal regime there was recognition of trade unions. What's the difference between recognition and the registration? And is it now more easier for unions to operate, or is it going to be more difficult for them to operate legally? What's your take, given the rights that are provided for in the Constitution to form or join a trade union of choice?
So essentially, under the previous regime, the Public Service Act as it is now, before these amendments are effected, the term trade union does not exist in the Public Service Act. There is no such word. There is only organizations and associations. But now with the amendment, they seek to introduce the term trade union. So trade unions are being placed in the same category with the associations and organizations. It will depend. But what is quite important is that the registration process now, which used to be the recognition under SI 45 of 1998, is now being done through registration with the Registrar of Trade Unions under the Labour Act. So Section 24 of the Public Service Act is going to be amended to say association, organization, or trade union is that entity that has been registered in terms of the Labour Act. So I think there's a sort of harmonization that all trade unions must be registered under the Labour Act. And so it then follows that all the rights and privileges accorded to trade unions under the Labour Act will follow those that are public service trade unions. So which is quite important, because the treatment that was being given to organizations or employee organizations under the public service was a bit lesser than those under the Labour Act. So, and what it therefore means that is that the minister was supposed to recognize and approve the unions for them to practice as unions under the Public Service Act. But that provision now it will be rendered a nullity because these are entities that are going to be registered under the Labour Act. So once a union is registered, there will not be need for an element of recognition, which was previously under the Public Service Act and SI 45. So the powers of the minister to recognize or to refuse recognition are no longer there because of the changes that are being brought.
Yeah, thank you so much. Now, there is this contagious issue, I think, which has been in the headlines, which obviously you might want to shed light on with regards to the conflict between the interests of the public service for it not to pursue partisan interests vis-a-vis the political rights of members of the civil service. Does the bill attempt in any way to come up with a balance? We understand that members of the civil service should not be engaged in partisan conduct, but we also understand that members of the civil service are also citizens with political rights. Is there an attempt to balance that one? Or?
Yes, thank you so much. So you note that the Constitution, I think it's Section 200 or so, it brings in the aspect that no member of the public service must act in a partisan manner, must be an office bearer of any political party, and stuff like that. So what the Act does is that it makes it a misconduct for any member of the civil service to act in a partisan manner in delivering service or functions as an employee. But what it further goes on to do is that it says that the misconduct will only arise if the employee is executing their duties. So if they are not executing their duties, they can actually exercise their freedom of association and assembly. But if they are doing their duty, they must be neutral. So I think one can actually attend their meetings, political meetings, rallies, as long as they are doing so outside the course of duty. But if they are on duty, they have to remain neutral and not prejudice the interests of any political party or organization.
Okay, that's great. Maybe we can also try to touch on the issue of appeals mechanisms. Maybe someone is aggrieved by how maybe the commission has handled the case. How does this bill really put out a framework for appealing to higher decision-making processes to seek recourse for maybe aggrieved parties? who might feel that maybe they've been unjustly treated by a decision-making process, by the commission.
So yes, yes. I think that's a quite important procedure in terms of dealing with conditions of employment, because obviously disagreements arise during employment. So the appeal mechanism must address two issues. It must address the grievance process. Then it also must address the disciplinary process. So you will notice that there are two distinct processes here. So the grievance process is where an employee feels aggrieved by the manner in which they are being treated in the workplace. Then they say, I'm not happy with this, I'm taking it with these superiors. So that grievance process, what we have not noticed is that the public service regulations, they have a procedure which must be followed. You go to your immediate supervisor. If you are not happy with their decision, you go to the next, and up to the commission. Then when it comes to the commission now, it seems as if the regulations as they are, the commission is the ceiling. You cannot go beyond the commission's decision. And the proposed amendment seems to be silent on that as well. What happens if I am not happy with the grievance decision of the commission? The act is silent, even the amendment is silent. So that particular aspect must be addressed. If you are not happy, you can either seek a review on the manner in which the decision was made, or you can seek an appeal to the labor court in respect of the actual contents of the decision. So that is, the act is silent. So we say it must be redrafted and incorporate a grievance appeal mechanism. Then in respect of disciplinary processes, there is quite a comprehensive appeal mechanism that has been set. The first step is one to approach the commission where the commission is not the disciplinary authority. So if the commission makes a decision, one is not happy, they can actually appeal to the labor court. So I think those are quite comprehensive provisions, though we do have issues with the wording of the provisions, which I think when engaged, the lawmakers can actually address the drafting, the way the provisions were drafted. But in terms of the process itself, what is missing is that there is no appeal against grievance decision, which must be addressed in the Act of Parliament, and not in subsidiary or regulations. It must be addressed in the Principal Act. Then in respect of the appeal mechanism, I think they captured it in a very comprehensive way.
Yeah, we really appreciate you taking time to shed more light on this bill. Maybe if you can just, in parting words, give your overall assessment on areas that you think might need to be improved, maybe areas that I never asked about, just your parting shots and overall assessment of the bill, and your word of advice to those who want to participate in the process of enriching this particular bill, areas to look out for.
Thank you. I suppose the key area that must be addressed by this bill is the right to collective bargaining. It must come in express terms that employees in the public service have a right to collective bargaining, and the process must be done in 1, 2, 3, 4 ways. Or they can actually say the process of collective bargaining must be done through a constitution, probably, or an institution set up by the employers and the employees, so that it may not be set up in a unilateral way by the employer. Then where it says conditions of service must be set up in through service regulations, I think the Act must be clear that the service regulations must come through a process of collective bargaining in the form of a collective bargaining agreement, which may be registered as a statutory instrument. So that comes quite clear that the minister and the commission cannot just determine conditions of service on their own. Then probably the other provision that we may think of is that when the Act deals with appointments and promotion, it must come out clear that there must be gender balance in terms of the appointments, taking into account Section 17, 18, 24, and 56 of the Constitution, for example. It must come out clear as well. Then, like I mentioned earlier, with the right to collective job action, I think the provisions must also be clear as to the procedures that must be followed, so that the process cannot be relegated to the commission and the minister, because there are two pertinent or major rights that are arising from the constitution: the collective bargaining and collective job action. So those rights must actually be fully embraced through the Act of Parliament itself, and not through service regulations that may be made later. So I think basically what I just want to implore civil servants and those interested in this bill is that they must participate in the public hearings, because if they remain silent, it may pass as it is, yet the bill is taking away certain rights, or it's not covering certain rights that are quite pertinent, like I mentioned, collective bargaining, collective job action. So the participation in terms of public hearings, or even written submissions to the Parliamentary Portfolio Committee on Public Service, Labor and Social Welfare, I think that would be quite important, to participate in all hearings that are supposed to deal with the bill. So I think that would be, yeah.
Yeah, we really appreciate you taking time to talk to us about this important matter. And there you have it, viewers. This is an opportunity to push for equality, given that this act, like what Edzai Matika says, can clearly define that recruitment, promotion, and whatever appointment should also take into cognizance the 50 provisions in our constitution. This should be the foundation where our public service lays the example for the private sector on the way they recruit, the way they promote and appoint, but also the fundamental issues raised around pushing for the right to collective bargaining to be more explicitly captured, pushing for the right to collective bargaining, collective job action to be also captured extensively. And we really appreciate you, the fact that you also spoke to the issue of regulations, pushing that the regulations should be made through collective bargaining. And we encourage citizens to participate in this process. The public service is the machinery that makes the nation works. And if we get it wrong, our nation can never move. And we want to urge all citizens to embrace the advice of participating in the hearings. We will be circulating an analysis of the bill that was produced by Edzai Matika and their firm, which we asked them to produce for the working class, and we will be distributing it for those who want to read and participate from an informed point of view. Until next time, this is the True Patriot Podcast, and thank you so much for viewing. Do not forget to subscribe to the channel. Until next time, thank you so much. Okay. Now we are suffering some. Something went wrong with my machine here. Okay. My machine seems to be under attack from some virus. I don't know how I ended up here. Sorry. I will.
Imwatunga miru benika. Ikuchema.